We will start now with Dealings in Land. This is lecture 8 of the course Dealings in Land, which is breach of contract. As you will see, this is a sort of a dual language lecture. My notes are in Bahasa Malaysia, that is for our students who will be answering in Bahasa Malaysia. And for those who will be answering in English, I'm delivering my lectures in English. So, kemungkiran contract is breach of contract. And what is the meaning of breach of contract? A contract for sale and purchase of property can be determined by any of the parties if there is a breach of a fundamental term. We've seen that in the former lecture. Generally, for every obligation in a contract for sale and purchase of property, time is of the essence. Time is very vital, and time becomes the essence of the contract. Therefore, should a term of the contract be breached, then the party who is not in breach, the innocent party, can actually claim that the other party can go for specific performance and or damages. So the innocent party has a choice of going for specific performance, because sometimes a vendor may have found another more lucrative buyer and he will try to get out of the contract with the current purchaser. And that the courts will not entertain, because when a purchaser is not in breach but a vendor is in breach, and it is found that a purchaser has a right to the property, then the remedy of specific performance and or damages will be granted by the courts. Once the liability of a contract that has been breached is proven, there are two questions which are involved in the assessment of damages. The first question is, damages cannot be awarded for breaches or something that has gone wrong, which is out of the contemplation of the parties. And secondly, when the court is assessing damages for breaches and for liquidated damages that are not too far out of the contemplation of the parties, then the proper or reasonable assessment to calculate damages must be used. The way that damages and liquidated damages generally are calculated will show the difference in price from the contract and the market value of the same property at the time the breach took place. For example, if the property had been sold to the purchaser, or rather the sale and purchase agreement had been they had concluded the price at 150,000, and now the vendor is in breach. He doesn't want to sell it to him anymore because the price of the property has gone up. So the innocent party, which is the purchaser, now has a right. He can ask for specific performance and or damages. What will the damages be? It will be between 150,000 and the current market value of the property. That will be the amount of damages that will be paid to the purchaser, who is the innocent party in this breach. So, when you have breaches in contract, the purchaser can be guilty of the following breaches. He did not pay the deposit, the balance of the deposit and the balance of the purchase money. A purchaser does not wish to continue with the contract, or he was in breach of the clause time that had been made the essence of the contract. For a vendor, for example, a vendor can be in breach when he had not given vacant possession at the time he is supposed to have given the vacant possession, or he does not have the title. Although I said earlier, you don't need to have the title at the time you sign the contract, but by the time the contract is concluded, you have to give and deliver as a vendor. You have to deliver the property free of encumbrances. Or thirdly, he may give free vacant possession, but the title may still have encumbrances. Encumbrances would be all those other interests. For example, there may still be a lessee on the land, or there could be squatters on the land, or perhaps there has been an easement that had been granted. Now, all of these are encumbrances, and a vendor has to satisfy the purchaser that he is delivering a title free of encumbrances. Or fourthly, a vendor just does not wish to continue with the contract. So, when we are talking about breach of contract, so the case of Sri Kalangkota Rakan Engineering and Arab Malaysia Prima Realty is clear. The Court of Appeal said an innocent party in the breach has the right to terminate the contract. But this again, bear in mind, the innocent party will try to terminate the contract only if it is a fundamental breach. Otherwise, he himself, as we saw earlier in lecture 7, he himself might be in breach. Then, we talked about encumbrances in the previous earlier slides. What are encumbrances? If there is a charge on the land, it has to be discharged. It has to be completely satisfied, and the charge has to be discharged and removed from the title. Any tenancy or lease has to be terminated. Tenancies, as you know, up to 3 years, you can enter what is called, you can enter onto the title that you have an endorsement onto the title that you have a tenancy for this period. So if it is not yet 3 years, it has to be terminated. Lease, similarly, whether it is lease for part of a land or lease for the whole land, it'll have to be terminated as well. If there is a caveat on the land, again, it has to be cancelled by the seller. In the case of Kaplan's Sendirian Berhad and Lee Chin Cheng Denkil oil palm plantations, the court was clear. The word encumbrance does not merely consist of conditions or restrictions in interest that normally appears in a document of title to land. It encompasses any matter concerning the land or its owner when any such matter, for example, fetters the right of the owner to deal with his land or to enjoy his land in the normal way. A private caveat, hence, is an encumbrance within the context of the National Land Code 1965. What are not encumbrances? Karpanan Chalapan and Chong Lee Chin had this to say. The phrase free from all encumbrances in the sale and purchase agreement could not be interpreted to extend to the condition on the protrusions and could not be said to be a misrepresentation that had induced the plaintiff into purchasing the property. The said words must be taken together with the words with vacant possession for its true meaning and intent. Viewed in that manner, encumbrances can only be interpreted as encumbrances that restrain a transfer of title under the National Land Code. Time, again and again, as we have said, is the essence of the contract. Once it is there, it is clear that that contract has to be read through carefully, and all clauses pertaining to time must be adhered. Payment of deposit, payment of purchase price. If it is the purchase price is to be paid in installments, then the time has to be followed strictly. However, a contracting party may waive the time is the essence clause. He is entitled to insist on time to be of the essence of the contract, truly, but he may, if he wishes, waive this right. This he can do by conduct or by words or by continuing negotiations without reservations. Under such circumstances, time is said no longer to be of the essence of the contract, but time has become of large. These are some of the cases that you may have to read through, and I'll advise you to go through each of these cases as they explain in detail what we have discussed so far. There are three ways whereby, after having read the cases, you will understand where time can be made again the essence of the contract, and that is after the waiver. The case of Chia Si Yin explains that in detail, and also the fact that the time can be waived is in the case of Webb and Hughes. So that brings us down to the end of lecture 8. Thank you.